Yes, good morning, Mr. Johnson.
My lords, my lady, I appear on behalf of the British Standards Institution, the appellant in this matter, Mr. Heppenstall, King's Counsel and Miss Foster appear for the respondent, RRR. Mr. Leary appears for the interested party, the MHRA. I should perhaps say at the outset, Mr. Leary and I don't presume anything by sitting in this row, but given the number of people in the court, we thought it was a sensible use of the space.
Well, I don't think we have any objection.
I'm grateful, my lord. By way of housekeeping, you should have 3 bundles, a core bundle, a supplemental bundle and an authorities bundle.
Yes.
By way of practicalities in terms of the submissions, I'm mindful this matter's been listed on an expedited basis. Has the court had an opportunity to read all the skeleton arguments?
We've read the skeleton arguments and we've read the judgment. And members of the court may have done a bit more reading. So we have a fair idea of what it's about, but probably not a complete grasp of the detail.
I'm very grateful. That's very helpful. And that leads on to the next point, which is the length or the timetable for the hearing. As you saw from the email, we had agreed a timetable that didn't make a provision for an extempore judgment, but did anticipate going to the end of this morning. The court invited the parties to think about whether they might need any more time.
Our initial view was that it might be a bit tight.
Indeed, my lord, and I'm looking at my notes and I'm being realistic, and on the basis of the principle that it might be better to ask for permission than for forgiveness, I anticipate that I'm likely to need more than an hour, realistically.
Yes.
I need to go through the
That
statute.
I think doesn't surprise us. How long do you think you want?
I hope I can be done in an hour and a half.
Yes.
Depending on how long Mr. Heppenstall needs, that may mean that we're still finished by lunchtime. It may mean that we need to come back to Mr. Leary in a reply, but we can take that as it.
Well, I think we anticipated that it might go into the afternoon, but would be unlikely to take the whole afternoon.
But look, I'm sorry, I didn't hear you over the drilling outside.
We anticipated that it might go into the afternoon, but would be unlikely to take the whole afternoon.
No, indeed, but I think, and that's absolutely consistent with my expectations.
Yes. Well, we don't want you to take up any time unnecessarily.
No,
you should have the opportunity to say what you want to say.
I'm very grateful.
Because I think there are important points of principle that you've raised, and I think we want full argument on them.
I'm very grateful for that indication. I trust that I will say only what is necessary, but I will make sure that I do say what I think is necessary. So, my lords and my ladies, as you're aware, this is the hearing of a rolled-up application for permission to appeal, and as appropriate, the appeal itself. The appeal arises out of the order of Mrs. Justice Laing, made on the 22nd of March 2024, and that's at tab 4 of the core bundle, and it might help to turn that up. It's at page 21. But before we go to it and before I address you in relation to it, just by way of brief background, the BSI is an approved body, and I'll return within the statutory regime to what that means, but the BSI is an approved body for the purposes of marketing medical devices in the United Kingdom. What that means in practical terms is that it's appointed by the Secretary of State, acting through the MHRA, to certify that medical devices are suitable for placing on the market, and it has an obligation to keep any such certification under review, and where appropriate to decide that a device should no longer be certified, and so to suspend or as appropriate revoke a certificate. RRR is a manufacturer of an innovative defibrillator. That defibrillator was first marketed in the UK under a certification granted by the BSI, so by the appellant, in 2022. And that original certification, and again I'll return to this in more detail, but that original certification was made following an abridged process. So following an abridged or a truncated process. It was a light touch file review. And that was because the device was already certified elsewhere in Germany. And just to flag this point at this stage, there's a difference between an abridged review because a device is certified elsewhere, almost the equivalent of a passporting process, and an equivalence application. An equivalence application is made on the basis there is already a device on the market, this is similar to this device, and therefore I don't need to provide the clinical data that would be necessary to show for the first time that this device works and is safe, and so on and so forth. Now, that is part of the factual context, because the original certification in Germany, the basis for the abridged process here, is on the basis of equivalence. But there's a difference between the abridged process because certified elsewhere and the equivalence process, which rests on the assertion the device is the same, or relevantly the same. And what's at the heart of the dispute between the parties in the underlying judicial review is that question. Is the question whether or not the device has been shown to be equivalent and therefore can be marketed on the grounds that it is safe and effective. So
you said I think that the German certification was on the basis of equivalence.
Absolutely, and the basis of the certification here is also on the grounds there's a certification in Germany, that's an equivalent certification, we make the same assertion here in the United Kingdom. So both are in play, but it's important to recognise the distinction between them, if I can put it that way. Equivalence is the assertion, my device is the same as something else. The abridged process is a different process, and it's a process that's undertaken where a device is already certified somewhere else. So it's a kind of passporting system, if I can put it that way.
Is that distinction between a bridge process and a rather fuller review reflected in the legislation, or is it just a matter of your policies?
Well, I'll take you to the legislation, my lord, but the answer is in part both, but also reflected in policy. In 2023, late 2023, the MHRA asked the BSI to look at the technical file. So they wrote to the BSI and said, we would like you to look at the technical file for this device. We have some questions. We have some concerns about it. There were exchanges between the parties, and the BSI reached the conclusion that this device should no longer be on the market under its certificate because there was insufficient evidence that it was safe and effective. And I place emphasis on the words insufficient evidence, and I'll come back to this, but that is the nature of the assessment that the BSI undertakes. RRR exercised its right to appeal. There was an appeal process. That appeal was dismissed. And that leads us to Mrs. Justice Laing's order. And the paragraphs that are the focus of this appeal in my submissions today are paragraphs 1 and 2 that I hope you have before you on page 21. So starting with paragraph 1, the defendant is restrained from suspending or withdrawing a UKCA certificate, so that's the category or kind of certificate that was granted, for the claimant's defibrillator device known as cell AED until the final determination of this claim or further order. So the BSI had reached the conclusion we are minded to, on grounds of public safety, suspend the certificate, but before it was able to do that, interim relief was sought on an urgent basis, and this relief was granted. So the factual position is that the BSI hasn't taken that decision, restrained from doing so by paragraph 1. Paragraph 2, prior to the expiry of the claimant's current UKCA certificate on or about 26th May 2024, the defendant shall exercise its powers so as to extend or renew the claimant's certification in such manner as it may deem appropriate until the final determination of this claim or further order. So paragraph 2 compels the BSI to renew that certificate. And the backdrop here is that prior to the hearing, my client drew the court's attention to the fact that actually this is all going to come to a head again, if I can put it that way.
How long do certificates last?
I'm sorry, my lord?
How long do certificates last?
I'm going to take instructions if I may, but I think 5 years is the ordinary position. This is obviously a briefer certificate. I can take fuller instructions on why, I don't think it's an issue between the parties, why it was set to expire in May of of 2024. As I say, my client, by way of his witness evidence, said, look, this is going to be an issue because in May 2024 this is going to come up, and made clear in evidence to assist the court, our position is that we're not going to renew. Barring things changing, obviously we're going to take everything into account at the relevant time, but on the evidence before us now, we form the view that this device is not demonstrably safe and effective, and on that basis we don't certify.
You may be going to take us in slightly greater detail through the facts, I don't know.
I am, my lord.
Okay, so when you were asked, when the BSI was asked to look at it again, or look at it in more detail, I think as you put it,
Yes.
was that on the basis that it's look again at the question of whether it's equivalent to something else which is on the market, or was it look at it, as it were, de novo, is it effective?
Well, my lord, the two things are closely connected. What was conducted was...
But they're not the same, because I thought you said that the basis for the German certification was that it was equivalent to something else which had been looked at. And so I'm just asking which of the two
was in view.
Yes.
So what was conducted is what's called a technical file review. So what that involves, the BSI looks at a range of different things when deciding whether the device is suitable to be on the market. Quality management systems is one of them, technical file review is another. And a technical file review involves looking at the underlying clinical data, amongst other things, to sustain the assertion that the device is safe and effective. Now in this case, that requires consideration of equivalence, because equivalence is the basis for certification, if I can put it that way. So it wouldn't always, but in this case it does, and it did.
But a manufacturer that is relying on equivalence simply needs to show that their device is technically equivalent to somebody else's device. They won't necessarily be able to show that medically, for example, that there's underlying medical evidence showing that a device of that type is effective.
So what is demonstrated clinically, as you say, is different. Rather than saying, here is a raft of studies that we've produced to show our device is safe and effective, what you say is, here is evidence that our device is equivalent to this device. If you're satisfied as regards that, then we rely on the universe of clinical data and evidence that underlies that device as demonstrating safety and effectiveness.
Even though we may not know exactly what it is because it's not necessarily publicly available to us.
Well, I think a good part of it is publicly available, my lord. But that's the logic chain, if I can put it that way. And so when my client conducted a technical file review, what they were looking at is the clinical data underpinning, and in this case, that's an equivalence assertion, if I can put it that way. And what my client wasn't satisfied about, first and foremost, was the assertion, our device works the same as this device.
Right, well, at some point, I hope you'll be able to explain exactly what the difference is. My understanding is that it's to do with energy and current delivery.
Well, my lord, I'm not sure. You're absolutely right. And the difference lies at that point. I'll take you to the assessment report that sets this out.
I hope you can explain it as well.
But I'll do my best, my lord. But that's the nub of the dispute, if I can put it that way, between the parties. Yeah. Is that the device, if I can put it in very simple terms in a nutshell, works differently. The level of current is lower, about half of that of the reference device in the state of the art. But it is said, don't worry, because actually, whilst it's true that the level of current is lower, the effect is the same across the cardiac muscle. And my client's position is that hasn't been made out. The state of
When
the
you
art,
say level of current, do you mean level of current or do you mean level of energy?
energy. My apologies. I'm very grateful, my lord. This is my GCSE physics teacher is rolling their eyes somewhere, no doubt. But you're absolutely right, my lord. So that's the difference between the parties on the clinical side. My client has said, in effect, you are asserting that it is the same.
Because in fact they assert that it's a higher current delivery.
But you haven't made out your case. We require the clinical data to demonstrate equivalence, and we don't see it in the case.
Yeah, but it's not equivalent to the other products, because the other products don't produce the same energy stroke current delivery. So it is attempting to look at the underlying clinical data to say that a higher current delivery, albeit lower energy delivery, is clinically as effective.
Exactly so. So there are two options open to RRR. It can either demonstrate equivalence. It can say, yes, it's different functionally, but the result is the same clinically, and therefore we're over the equivalence hurdle, or they can do the clinical studies necessary to show...
Yeah, but it's not, as it were, product equivalence, because it's different.
Yes.
It actually delivers different current. Different energy stroke different current.
Yes.
So it's clinical equivalence,
Yes.
You're saying, is the deficiency.
Is the nub of the point.
Is that right? I mean,
yes, my lord,
I'm
right. I can be corrected if Mr. Hexford disagrees, but that's what's between the parties. The devices are obviously different devices in literal senses. They're different devices. It works slightly differently, is RRR's case, but don't worry, it's actually the same clinical result. And the BSI's position is, you haven't made out that case. You haven't made out and demonstrated to us, by reference to the relevant clinical studies that are necessary to show equivalence in order to therefore rely on the hinterland that lies behind this other device of the underlying clinical studies there. So that's what's between the parties.
Well, you're not going to be relying upon the underlying clinical studies for the other device, because if your device doesn't work in the same way, in this particular sense, their clinical studies are going to be irrelevant to this device, surely.
Well, if...
Or not irrelevant, but not directly relevant.
No, indeed. And that's the position that the BSI is in. The BSI's position is, we've looked at the technical file. It rests on the assertion of equivalence. The mechanism, if I can put it that way, current is different. It's not state-of-the-art. It's about half of what is state-of-the-art. Therefore...
You said current again.
Sorry, my apologies. Therefore...
My understanding is that energy is measured in joules, and
Yes.
there's a figure for joules in the literature of what is normal, and the number of joules of this device is about half.
Yes.
But RRR say that's not what is important. What's important is the current across the heart, and ours does the same. It does it in a different way, but it does the same. So as my lord says, you're not saying, here's a product which works in exactly the same way, and that's certified, so we are equivalent to that. Saying, here are products which deliver the same current as us, and we say, although we do it in a different way, we get to the same result. And you say, what you're telling us is, the BSI says, well, you haven't shown that.
Exactly so. You haven't shown the two steps of the assertion there, which is, A, we produce the same result, and B, that result is clinically equivalent. So there's agreement between the parties that it's different, if I can put it that way. What's not agreed between the parties is whether that difference can be overcome by the evidence that's relied on by RRR to say, yes, we accept it's different, but don't worry about that, because the current is the same, and the current is what is operatively necessary and important.
And the number of joules is irrelevant to that. I think that's their case.
Yes, I think that is their case, my lord, and that's really what's going to underlie the substantive judicial review, if I can put it that way. But that's the nub of the dispute. The dispute is if I can put it this way, it's a technical, clinical dispute about data and equivalence and the effectiveness of this device. And the BSI's conscientiously reached conclusion, in the light of its considerable expertise, is that RRR hasn't made out its case. And the burden lies on RRR to make out its case, and therefore this device should not be on the market. I've taken you to the order. You have the point about renewal of the certificate. So there's a sort of double limb here, if I can put it that way. Firstly, may not withdraw. Secondly, must recertify.
What date is the JR going to be heard?
That's currently being canvassed between the parties and the court, and it's not proving easy to find a date, in part because we currently have a 3-day listing and there is some discussion about a 2-day listing, but the window from the court is 26th of June, which in some ways doesn't help us because I think it's a Wednesday and then a 3-day listing, therefore it couldn't be the 26th of June, it would have to be the week after. 26th of June through until, I think, 26th
Sorry,
of July.
so run that one past me again. You've got a
So
3-day
because
listing.
it's a 3-day listing.
You start on a Wednesday.
It would, well, the 26th of June, the beginning of the window, is a Wednesday, and so because the administrative court doesn't sit on a Friday, we'd either have to sit Wednesday, Thursday, Tuesday, or more realistically, we'd have to go into the next week. But in any event,
Unless that rule is capable of flexibility in the administrative court.
well, that question has been asked certainly of clerks. I don't know how directly that question has been put to the administrative court, but the window in any event, my lady, is 26th of
So
June.
we had next term, so that's quite quick, but it's not quick enough to get there before the 26th of May.
No, indeed. And that was agreed between the parties at the last hearing, that it wasn't going to be practical to prepare. In fact, at the last hearing, RRR's position was that it was going to need to reduce expert evidence as well. That is something that shortly before Easter RRR said, actually, we don't intend to call expert evidence, and that's made it more possible to truncate. But no, it was agreed this was not going to be resolved by the 22nd of May. And so that's why this question arose, drawn to the court's attention by my client, and that's the origin of the mandatory order that says, whatever you think, whether you think this is safe or not, whether you think this is effective or not, you must certify the device. And I don't think I need to make the submission. You'll anticipate precisely why that causes...
We've read your skeleton.
Indeed, I'm grateful. 3 short points by way of introduction to orient the submissions before I go any further. First, I don't shy away from the obvious point that this court will only interfere with the finding of the court below if it's satisfied that it rests on an error of law or an error of approach. I'm going to return to have more at a later point in my submissions, but just to anticipate the submission now, this is not what the respondent calls an attempt to have a second bite at the cherry. On the contrary, the premise of this appeal is that the judgment below rests on an error of law, and that's a hard-edged error of law concerning the nature of public safety in this field, what public safety means. And I'll make that good, I hope, from a combination of the statutory regime and the judgment. Second, and connected to the above, this appeal is about public safety. I've made this point again, so I won't labour it now. But in short, a device is safe if the party that wishes to manufacture and market the device can show that it is safe to the satisfaction of an approved body. The burden of proof as regards safety lies with the manufacturer, and the role of the approved body is to exercise its competence and its expertise and to determine whether the case for safety is made out or is still made out if it's reviewing an existing certificate.
I mean, when you say safety, I mean, I'm assuming I'm mentally replacing that word with effective.
Indeed, my lord, I think in this context, the gap between safety and effectiveness is little or nothing, because if a defibrillator doesn't work and hasn't been shown to work, then it couldn't possibly be safe.
Well, I mean, okay, I mean, I don't want to get into undue semantics, but it's basically, it's not going to kill you. It just isn't going to save you.
No, indeed, but
and therefore, you know, in a sense, it's just not effective, and therefore it might, in a sense, be thought to be unsafe, that somebody might use it rather than something else.
So precisely so. So what is in issue here is not that the device will do you harm proactively by virtue of being in the same room as you and exploding, or whatever it might be, or causing you harm in its use. What is in issue is that the BSI is not satisfied that it works, and effectiveness overlaps, if I can put it that way, with public health and safety in that sense, in the sense that this device is used, and it's a stark example, we say, this device is used in extremis at the point at which the person is at the door of death. And so if it doesn't work, the public health consequences of that are very severe, and whether that's framed as a public health consequence or a safety consequence, we say it leads to the same point, which is that in a circumstance of this kind, the burden lies on the person wishing to market to demonstrate that the device works. And we say that I hear your...
Is there a difference in terms of exercise of discretion and grant of injunctions between something which could actively harm somebody if used, and something which just might not work to save them if used?
Well, we say that, really, you put your finger precisely on what we say is the error of law, actually, in this judgment.
No, I'm just putting the question out. So.
And the question as regards this statutory regime and this kind of device is that it works in this way. The BSI is not asking itself, almost ever, does this device explode and cause you harm? The BSI is asking itself, does this device work? Have you demonstrated that it's effective and safe? And so the question whether it's unsafe is almost never in the BSI's mind. But the question whether it's safe as demonstrated, we say, is a very weighty public health concern.
Right, but when you're addressing public health, I mean, what the question I'm posing is whether from the court's perspective in deciding to grant an injunction, there might be a difference, and it's an open-ended question, I don't know the answer, between a product which should, as it were, is said, shouldn't remain on the market because if used it could be positively harmful, and a product which if used, and it may be the only thing that's there to use, just might not work. No, I mean, as you say, this will be used in extremis, almost by definition, when there is no other defibrillator around.
And I suppose maybe
and I'm just, you know, I mean, if this was a product which, if used, would certainly kill the person to whom it was applied, I can understand that's a very extreme scenario for the court and indeed the PSI and everybody else. If it's a product that just, it stands a chance it might work, but it just might not. But frankly, there's no other alternative other than manual resuscitation. Then the question is whether for the court there is any difference in approach in the grant of an injunction of this type.
So I suppose two parts to answer the question. First, a practical answer to the question, which is that what's not in view is a product recall here. So what's not being suggested is this device should be taken out of people's houses or whatever it might be. The question that's being asked here, and that falls to be determined as regards injunctive relief, is whether or not this device should be further sold. And that's being answered against the backdrop of context where there are plenty of other, if I wish to buy a portable defibrillator, I don't have to buy this portable defibrillator, I can buy a different portable defibrillator. So that's the context. If we were talking about a device recall, then the question, is it going to explode and or cause harm, might be the central focus. But from the court's perspective, in this case, what safety means and what public health requires and what the BSI considers and the court has to put, we say, properly understood into the balance of convenience assessment is this question. Is this device shown to be safe? Should it be on the shelf being sold to people who will purchase it in preference to other devices?
Right, well,
So I think the difficulty that you're having with my lord is you're constantly using the word safe, whereas what you really mean is effective.
Yeah, that's
Now,
exactly
yes.
it.
I entirely understand that you don't want people buying things which don't work, but to call that safety is not the same as what you call a product recall case, where the device itself can positively cause harm. It's just that your concern is medical devices that are sold to the public should be ones which work, because you don't want people buying things which don't work.
No, indeed. My lord, I'll take you to the statutory regime. The statutory regime uses at certain points the language of safety. The decision in question, the decision under challenge, has used the language of safety as well, consistent with that. But I hear the point that's being put to me, which, as I understand it, is to say, are we really talking about safety here, or are we talking about effectiveness? And I suppose my submission in response to it is that there isn't a bright line distinction between those two in circumstances where I can buy device A or device B, but if I buy device A and it's not effective, that is going to cause me harm in the sense that I need my defibrillator and it doesn't work. Yeah. And I could have bought a different device. And so, my lord, I don't think there is the hard-edged distinction, if I can put it that way, between effectiveness and safety in this context, albeit I accept that safety can have another or a different meaning, which is bring the device back, it's causing harm. And we're not in that context, and it's been clear at all stages.
Or even, I mean, and I do have to say, I don't know whether I'm the only one struggling with the noise that's outside. But
it's certainly not assisting me, my lord, but
no, I know. I get your point about this is to do with sales in the intervening period.
Yes.
In fact, and therefore you're saying, well, there shouldn't be two products on the shelf if one of them has been established to be effective, or as effective as a defibrillator can ever be.
Yeah.
You know, because it's no one guarantee that it works
No,
by a long shot, and one which hasn't been proven to be as effective.
Yeah.
And therefore,
or indeed, to put it more strongly, hasn't been proven to be effective at all to the relevant standard. And there isn't sort of a sliding scale of effectiveness here where a device might be a bit effective or halfway there. The question for the BSI is, are what the legislation calls the essential requirements met? Answer no.
right. And so you say it's a question of effectiveness, which is what is at the heart of this.
Yes.
Because by definition, we're not in the territory of a product which, if used, will, as I say, definitely kill you.
No, this is not an
This is not not an overpowered defibrillator.
That would be another possibility.
You know,
the defibrillator is so overpowered that it is likely or highly likely to cause you harm by
irreversible harm
by destroying your heart. But this is the nub of.
Yeah. Okay. Well, I get the point, but I wanted to pick you up because there's a constant. There may be another case which is what I'd call a proactive safety case.
Yes.
Where you actually have two products on the shelf, and one of them will actually harm you if used.
Yes.
You know, you can think of all sorts of things in a different context that will actually, if used, harm.
Yes.
Corrosive substance or a chemical that actually is suddenly proven to cause harm. This isn't one of those cases, as I understand it. It's an effectiveness case, which has ramifications for the safety of an individual in the broader sense of whether they should have a chance of surviving a heart attack. And all I was asking at the start is, can we try and use the word effective, or at least address that issue, if you say it's relevant to the court's exercise of discretion, because just badging this as a safety issue doesn't, I think, probably help.
Now, my lord, the only thing that gives me some pause at this point is that I've been passed a note. I'm conscious that within the papers there is some discussion of, albeit not the focus of the discussion between the parties, about neonatal use in this context.
There was a suggestion that in certain circumstances it might be dangerous.
Indeed, in a neonatal context.
Yes.
And the device is marketed for neonatal use, as I understand it.
Yeah.
So there is.
But as you say, that's not really the focus of the argument.
It is not the focus of the argument. It is not the focus of the submission, or the focus of the reason why the device was not, or why the decision was taken to suspend. But also, in fairness to my client and the totality of the factual picture, I do need to say that there is actually at least a part of the picture where there is a concern about what might be called proactive safety.
Can we use the term dangerous?
Dangerous.
Because a product dangerous can actually harm you.
Yes.
I don't think a lack of effectiveness makes a product a dangerous product. It is a concern which you badge under the global term safety because, for the reasons you explained, you don't want people to buy things when they turn out not to work when they need them. But that doesn't make them dangerous, it makes them useless. And hence imperils people's safety in that sense, because they've got a useless product when they need one which works.
Yes.
But that's not quite the same as saying you've got a dangerous product.
No, indeed, and it's never been the BSI's case that it is a dangerous product, but you'll anticipate precisely why the BSI is so concerned about what you've aptly referred to as a useless product. in the context of a defibrillator. And in particular concerned that it's being told, you think this doesn't work, but you can't act on that conclusion, or at least put it more precisely.
It's not that you think it doesn't work. Your whole point is you haven't demonstrated to us that it does work.
Indeed, sir.
And that's a very different point.
To the required standard.
Precisely.
Because nobody can guarantee that a defibrillator works.
Well, no, exactly so. There are certain essential requirements that must be met. You have not met them.
Yeah.
That's the position. You've not satisfied us that this device works.
And all I'm trying to do, and I'm sorry if it's taken me too long
not at all.
out of your time to do it, so take your time. But I think it's quite important that this case is not conducted on a sort of loud, shouty basis.
No, indeed.
About this is all to do with public safety, because that label is capable of covering a multitude of discretionary factors, shall I just put it that way, as I see it at the moment.
Yeah. And the linguistic precision is important when we come to the judgment, because when we come to looking at why it is that Mrs. Justice Laing decided that she was going to grant interim relief, just to anticipate the submission, I know you've seen it, she starts by saying public health is a paramount factor. However, there's no evidence this device is unsafe. And we say that that is an error of law. Because, yes, public health is a paramount factor, but she's discounted it from the balance of convenience altogether. What she's effectively saying is, were it in the balance, I'd be refusing interim relief. But it's not, because nobody's shown me that this device is unsafe. But that's never been the BSI's position. The BSI's position is that, consistent with the way the statutory regime works in this context, it hasn't been demonstrated to be safe.
Yes.
And that is a more than sufficient condition for it to not be on the market, in the BSI's view. So that's to anticipate the submission.
Be effective.
I'm very grateful. My third, and I'm conscious you've read the skeleton argument.
Sorry, well, before we leave this point, Mr. Johnson, sorry, may I ask a question, please?
Indeed.
Does it follow from what you've said so far that your answer to the question that my Lord Justice Snowden asked a while ago, i.e., should the court's attitude be different depending on whether a device is actively dangerous or just not shown to be effective to the required standard, would it follow that your submission is the court's attitude should be the same?
Well, so it's a slightly difficult question because we're not considering a statutory regime in which dangerousness is the operative question.
No, but I mean, I'm just going back to the question that you were asked by my Lord.
I suppose let me put it this way. I don't need to make the submission that they're precisely the same, right, because I don't need to go that far to satisfy you that there's an error of law in the judgment below.
Okay, well, that's very helpful.
So I'm not.
It might be if it was a dangerous product, you would have a stronger case.
Indeed.
But we're not in that territory. We don't need to decide that.
Precisely so. So I'm not making the submission that those are coterminous considerations.
No.
The submission I'm making is I don't need. I don't need the device to be dangerous in order for you to be concerned about the rationale of the judgment. And indeed, one of the concern about the rationale of the judgment is that the critical operative part of the reasoning is to say it's not dangerous, as to which my client says that's not the relevant question.
He never said it was.
That's not the operative question.
Yeah.
My third opening submission was going to be to say that my client hasn't brought to appeal likely, but you've read my submission. I think I've made the point already. If I can just very briefly ask you to turn up Mr. Tunbridge's first witness statement, which is in the supplemental bundle at tab 12 and page 295. What you have here, my apologies, I've picked up the authority, so I'm slightly behind you, I think. What you have here is, here we go, 2 years worth of my client's work summarised, if I can put it that way. And so, tasks leading to certification, 6,500, tasks leading to refusals, 520, albeit there's a gloss on that because Some things may be categorised as a refusal where actually it's withdrawn. Tasks leading to suspension 51, tasks relating to cancellation 828, albeit again that may capture within it a number of different steps. But the point I draw your attention to is tasks relating to suspensions 51. And the submission is a rather basic one. It is an important and a mainstream and a regular feature of my client's work to consider suspensions. In any month, very crude terms, they are suspending 2 devices. Over a 2-year period, 24 months, that's roughly where we are. And that is part of the reason why my client is here, because you'll anticipate my client.
So what's a task?
I think that is.
I mean, is a task related? It doesn't say they suspend 51 products over 2 years.
My instructions are that is what it means.
Why doesn't it just say suspensions?
I think the nomenclature that's used internally is that they have a framework where everything is referred to as a task, if that makes sense. And so you have a task leading to certification, that might be abbreviated to certifications.
Right,
but
so these are just suspensions, cancellations, withdrawals, refusals.
Indeed, though within the category of cancellation and refusals there's a bit of a gloss because they may capture a number of different circumstances.
But I could just ignore the word tasks.
I think the word tasks
relating to doesn't add anything at all.
Without being dismissive, I think that may be process speak, if I can put it that way, rather than anything.
There's a lot of that in these documents that I would be really grateful for you to cut through.
I will do my best, my lord, to the extent that I'm able.
Just makes them impenetrable in places.
And just turning over the page, Mr. Tunbridge just provides a brief series of examples of the kinds of circumstances that are in view. So if we take the 5th one down, T00366498, manufacturer failed to provide acceptable corrective action plans to non-conformities raised during a technical documentation audit, which led to certificate suspension. More non-conformities were raised during the suspension period and led to certificate cancellation. But the first half of that description is precisely what's happened in this case. And the point I'm making is a rather simple one, which is that the process of reviewing is always happening as regards certificates. The process of suspension is by no means unusual. And the BSI's concern is that its power to suspend is, I don't need to put it too high, it's not been entirely neutered, but it is certainly circumscribed by the judgment below. Because a company in RRR's position only needs to come to the court and say, the BSI wants to suspend our certificate, we want urgent injunctive relief, we're going to suffer commercial harm, and the balance of convenience lies in our favour because there's no evidence that this device is going to cause active harm.
Well, they also have to put in statements of facts and grounds which are sufficient
To meet the
to get over the hurdle of permission to apply for judicial review and a serious case to be answered.
Yes, indeed, albeit the difficulty my client was placed in this case was that it didn't have time at the interim relief stage to file.
You haven't put your defence in.
We haven't put our defence in because we didn't have a chance because interim relief was brought on in circumstances where we hadn't yet taken the final decision. Bang, interim. In fact, at first it was going to be pre-action interim relief. The court said, don't do it pre-action, you're going to need to put in a statement of facts and grounds. Statement of facts and grounds, we were then ordered to provide our evidence within a small number of days for a hearing 2 or 3 days thereafter. So, I mean, you've seen my submission. We don't accept that this is a strong claim, but we do accept in the circumstances that we were not in a position to say, consistent with
There's no serious issue to be tried.
That there wasn't a serious issue to be tried for the purposes of the balancing convenience. So
Yes, my point was simply that I think you put it too high when you said all that a manufacturer in RRR's position has to do is say, this will cause me commercial harm and you haven't shown it safe. They have to put together a sufficiently arguable case to get over the initial hurdle to get a JR off the ground.
No, indeed, and that's why my submission, and maybe I put it too high slightly later, I was very careful not to say this renders, I don't put the point too high and say this renders my client's power to suspend entirely neutered, but we do say that there's a real circumscribing of that power here, that the ordinary position where a claimant has a case that it can put together and then seek urgent relief is that it's going to be very, very difficult for my client to say, well, see the judgment of Mrs. Justice Laing, actually this case is completely different because we can show you that the device is dangerous. Well, that isn't what my client almost ever does. Yes, of course, it must happen on a small number of occasions, but the precedent, if I can put it that way, is very, very concerning from the perspective of my client. So that's the general concern, if I can put it that way. That's why
I think we understand that.
my client is here. Of course, there's the particular concern about this particular product, and it might be easiest to pick that up in the core bundle at tab 13A at page 189. And we'll return to this because I'm going to take you through this document more fully. Sorry, I think I've said 189. I think I mean 179. My apologies. Yes. So the paragraph that I draw your attention to at this point, this is one of the major non-conformities found following the technical file review. And just below area process clinical evaluation, the CER package is not compliant to state-of-the-art methods, fails to supply sufficient data in support of the device under review, including but not limited to the following identified gaps. At this time, there is not considered to be evidence in support of safety and efficacy of the device. So that's the specific concern that I've been articulating. So as well as the general concern about the logic, if I can put it that way, or the structure of Mrs. Justice Laing's judgment, there's the particular concern relating to this device. My client does not want to certify this device as suitable for sale. It's currently compelled to do so, and even more so compelled to renew. So moving on now to address the four headings that I want to address you on. I hope I can be a little quicker because we've already canvassed a number of points, but I'm conscious that I may take a little longer than I indicated at the start. Starting first with the statutory background, then I want to address you on the factual background, then the law, and then the specific grounds of appeal. So starting with the statutory background, if you could take up Authorities Bundle 12. I should apologise. No, apologies. It's Authorities 11, actually. This is the medical devices regulations. This is unfortunately the version from Westlaw because the other versions available are still currently pending updating. The regulations.
I don't know that we needed all 244 pages of it.
No, indeed. The difficulty being once it's been extracted from Westlaw, you can't remove pages from it if it's legislation because you need the override in order to do so. So that's the difficulty. Certainly my Adobe Acrobat Pro didn't let me because I asked myself precisely the same question, can I get rid of whole parts of this? And I failed to do so.
Just because you have to print it all doesn't mean you have to photocopy it all.
No, indeed, that's true, my lord, and I take that point. The regulations set out the functions of the approved body, which is the BSI. They set up the balance of obligations, if I can put it that way, between an approved body and a manufacturer. And just to anticipate the submission at this stage, what's clear from the legislative regime is that the role of the BSI is to assess, canvassing whether or not the statutory essential requirements are met, and the burden for showing that lies with the manufacturer. That's the balance of obligations or competence between them. So starting with page 204, so we have the definition there of an approved body, which is to be construed in accordance with Regulation A45. We'll come to that shortly. Then turning through to page 207, relevant essential requirements. So the relevant essential requirements in relation to a medical device means the essential requirements set out in Annex 1 of Directive 9385, Annex 1 of Directive 9342, or Annex 1 of Directive 9879, which apply to it, but not including in the case of a device intended for clinical investigation, that doesn't apply. It's agreed between the parties here that Annex 1 of Directive 9342 is the operative provision in this case. And we do underline the words essential requirements. This is a framework under which it is necessary to meet the statutory conditions precedent, failing which the device cannot be marketed. So turning through to Regulation 7, I know this is a bit of a whistle-stop tour, but the regulations are very lengthy. I hope I'm giving you enough of them. So Regulation 7 on page 238 sets out the classification of general medical devices. So for the purposes of this part and part 6, devices are classified as belonging to class 1, 2A, 2B, etc. in accordance with Annex 9 of the directive. It's not in dispute that this is a 2B device. So there are specific obligations that apply in relation to this kind, if I can put it that way, of device. Turning forward to Regulation 8, which we find on page 241. Subject to Regulation 12.
Paragraph 7 just deals with the classification, doesn't deal with the essential requirements. It's just a classification question.
Precisely so. It's 2B, the requirements sit elsewhere.
Right.
Regulation 8.
There seem to be two versions of Regulation 8.
Well, the difficulty is one of them will almost certainly be marked Northern Ireland and one of them will be marked England, Scotland and Wales. So this legislation, unfortunately, post-Brexit, every single regulation, or very nearly every regulation, is duplicated but slightly different as between Northern Ireland and England, Scotland and Wales because particular provisions apply arising out of the unique position of Northern Ireland. So that makes the provisions even longer, unfortunately, for these purposes. Subject to Regulation 12, no person shall place on the market...
I think you want the one on page 240 because looking at the footnote, the notes, the one on 241 is Northern Ireland, limited in its application to Northern Ireland.
My Lord, I thought it was the other way around because it says Northern Ireland above Regulation 8 on page 240.
In tiny writing in a little grey box.
Oh, yes.
And then on page 241 it says England, Scotland, Wales, and so you have two Regulation 8s.
Oh, I see. Okay.
You're absolutely right, my Lord. These are not the easiest regulations to navigate, if I can put it that way. Subject to Regulation 12, no person shall place on the market or put into service a relevant device unless that device meets those essential requirements set out in Annex 1, and that's Annex 1 of the directive, which apply to it, and the requirements set out in Regulation EU 722/2012 if applicable. So again, this is setting up what the obligations are, but just to underline the no person shall place on the market provision, it is actually a criminal offence to breach Regulation 8, and that's in Regulation 60A. I won't turn it up for your purposes. But that is the framework, if I can put it that way, of obligations. If you don't meet the essential requirements, you can't place it on the market, and if you do, it's a criminal offence. Turning forward now to Regulation 12, for which I think the appropriate version is on page 250, near the bottom.
Yep.
So Regulation 12, Northern Ireland is above it. Regulation 12, England, Scotland and Wales is below it. And turning just over the page to paragraphs 6 and 7. Regulations 8 and 10, so this is the obligation about placing on the market, or not placing on the market, unless the requirements are met, do not apply where the Secretary of State directs that a relevant device or class of relevant devices which meets other requirements or standards or which is marked other than with a UK marking, which the Secretary of State determines is equivalent to the requirements and standards imposed by Regulations 8 and 10, may be placed on the market. Now this is important because what this means in practical terms at the moment is that the Secretary of State has, for now, decided that a CE certification makes a device suitable for placing on the market. There's a difference, as you recall from the Skeleton argument, between a CE certification and a CA certification. The CA certification being that in the United Kingdom. And just picking up briefly, paragraph 7, which I think is helpful contextually, the Secretary of State in determining whether another standard or requirement is equivalent must be satisfied that the other standard imposes a degree of safety and quality equivalent to that imposed by these regulations. So we do say, consistent with my submissions before, that meeting the essential requirements, meeting the requisite standards, is described here and elsewhere as being a matter that goes to safety. So that is Regulation 12. Regulation 13, turning through to page 253. Here we have the specific Class 2B obligations, in paragraph 3, a relevant device falling within Class 2B may bear a UK marking, so that's a CA marking, only if its manufacturer fulfills the applicable obligations imposed by Annex 2, again of the European Directive, excluding Section 4, Annex 3, and declares in accordance with the Declaration of Conformity procedure that the device meets the provisions of this part which apply to it, and so on and so forth. So here you have the specific obligations. I'm taking you through these to show you the structure and logic, if I can put it that way, of the statutory regime. And again, the simple point is, this is an in or out regime. This is a regime where obligations are met or they are not met. Moving on now to the role of approved bodies, that requires us to move quite a long way forwards in the statutory regime to A45, which is at page 335. The meaning of an approved body. So if you recall right back in the definition section, we looked at what an approved body is. An approved body is a conformity assessment body which has been designated by the Secretary of State pursuant to the procedure set out in Regulation 45, and then there's a provision for parties that were already a notified body under EU law. So this is what my client is. This is what the BSI is. It has been designated by the Secretary of State. It is not the only approved body in the United Kingdom by any stretch. There are a number of approved bodies, and there's provision I won't take you to elsewhere within the statutory regime that basically sets up a framework whereby they are entitled to contract with companies who wish to market, they charge them fees and so on and so forth. And that lies behind the submission that I should make only in passing, which is that my client has actually reserved this position about whether it's amenable to judicial review on the grounds that this is a contractual relationship. But that is not a question for today, and we take no point in that respect today. But that's what my client does, or that is how my client has been appointed, and where it says by the Secretary of State, what that means in practice is by the MHRA. Regulation 45, over the page, Secretary of State may designate for the purposes of these regulations any corporate or other body as a body which is to carry out the tasks of an approved body, that's the BSI, and if he so designates, he shall designate the tasks which it is to carry out. So that's where my client, if I can put it that way, comes into the picture. Turning forward to page 342, general matters relating to approved bodies in Regulation 47. An approved body to which an application has been made by a manufacturer. So that's the position we're in now. RRR makes an application to my client. They say, there's a buffet of people we can go to, there's a buffet of companies we can go to, but we'd like you to be our approved body to perform the functions of an approved body under a conformity assessment procedure set out in these regulations. Now, I won't develop this in detail, but the basic point is this. A conformity assessment procedure involves asking the question, are the statutory conditions precedent, are the essential requirements met? Shall perform those functions in accordance with the requirements of the procedure if those functions are within the framework of the task the body's been designated to carry out. We can only do what the MHRA has told us or has designated us to do. Where a manufacturer or manufacturer's UK responsible person has supplied information or data to an approved body in the course of a conformity assessment procedure, that body may, where duly justified, require the manufacturer to provide any additional information or data which it requires necessary for the purposes of the procedure. That's just a fairly straightforward point, but my client's entitled to say, we need more data, we need more clinical evidence, we need more information as appropriate. Paragraph 4, an approved body shall, as respects a medical device which is assessed, informed all other approved bodies and the Secretary of State of all certificates suspended or withdrawn, on request all certificates issued or refused, and shall make available to them on request any or all additional relevant information. So here we have the idea that not only does my client grant, but it potentially suspends or withdraws as appropriate. Paragraph 5, where an approved body finds as respects a medical device which it has assessed that A, the applicable requirements of these regulations have not been met or are no longer met, or B, a certificate issued by it should not have been issued, it may having regard in particular to the principle of proportionality and the ability of the manufacturer to take appropriate corrective measures, suspend or withdraw the certificate issued in respect of that device, or place restrictions on it. So this is the function that my client is exercising here. Parliament anticipated that there is going to be a process of ongoing review, ongoing scrutiny, and that it may be appropriate in circumstances to suspend or to withdraw, and the factors to be taken into account include the ability of the manufacturer to take appropriate corrective measures. And just to play this forward, you'll have seen in the documents that my client has been asking for corrective action plans. We've been saying, we're not satisfied, send us a corrective action plan. RRR's response is, because we don't accept the premise of your conclusion, we're not going to provide you with a corrective action plan. We think this process is flawed analytically. We've said you can have more time for a corrective action plan if you want to. They say, no, we're not going to submit a corrective action plan because we can't, because we don't accept the rationale of your finding as regards equivalent. So that's where the parties have got to. I'm not proposing to take you hardly at all to what we have behind tab 12. Tab 12 is the relevant EU Directive 9342. Now, I think Ms. Foster or Mr. Heppenstall, eagle-eyed, identified that actually the version you had before you was not the version as of IP day, and therefore we do actually have another version to hand up, I think. Has it been given to the court already?
Just by your side.
Oh, it's just by my side. Could I possibly hand these up to the court? I'm very grateful. I'm going to be very brief with this, partly because I'm mindful of the time. I'm very grateful. I don't think it actually makes any difference to the provisions that I was going to take you to, but I do want you to have the appropriate version. But whilst it's coming towards you, because the recital is, as I understand it, the same, looking at the fourth, I think it is, or maybe third recital, whereas the content and scope of the laws, regulations and administrative provisions in force in the Member States with regard to the safety, health protection and performance characteristics of medical devices are different. That is the rationale, if I can put it that way. So again, at the heart of the EU directive to which reference is made, safety and health protection are the key concerns, and that's part why my client...
And performance characteristics.
And performance characteristics, precisely so. That's why my client articulates its concern in precisely the language that it does. If I can take you now to page 29, to Annex 1, general requirements. So there are specific requirements, and Annex 10 contains requirements as regards data and clinical data. I'm not going to take you to those, but just the first paragraph of Annex 1, the devices must be designed and manufactured in such a way that when used under the conditions and for the purposes intended, they will not compromise the clinical condition or the safety of the patients and the safety and health of the users, or where applicable other persons, provided that any risks that may be associated with their intended use constitute acceptable risks when weighed against the benefit to the patient and are comparable with a high level of the protection of health and safety. So again...
Why is that going back? I'm sorry to gnaw away at an old bone.
No, do not.
Why are you referring us to that as opposed to a requirement of, as my lady put to you, performance characteristics, or that the thing works?
Well, my lord, this is the overarching general requirement which encapsulates...
you don't say, as I understand it, or sorry, it's not suggested that there's any risk of not meeting the relevant standard in terms of compromising the clinical condition or safety.
Well, I'm not sure my client does fully accept that. I think we would say that the clinical condition and safety of the patient can be compromised not only by active harm, the archetypal exploding device, the clinical condition and safety of the patient needing a defibrillator whose heart is stopped is compromised by a device that doesn't work. So we do say...
Well, it's compromised because the heart has stopped. It just isn't started again.
Well...
I mean, is there an equivalent to this to deal with inefficiency, devices that don't work? Because if there is, then just point me to that and I'll shut up.
Paragraph 3, my lord. Is the
Paragraph
performance.
3. That's very helpful.
Right, thank you.
The devices must achieve the performances intended by the manufacturer,
That's
be designed,
right.
manufactured, and packaged in a way which is suitable for one or other of the functions. So, my lord, I don't wish to gnaw back on the bone in response, but I understand the point that's made, but I think my client would say that it's a slightly peculiar reading of the concept of compromising the clinical position of the patient to say, just because a device doesn't work, that doesn't compromise their clinical condition. We would say it does compromise their clinical condition. Not in the same way as it would if the device burned them or blew up on them, but it still compromises their clinical condition, because what they're looking to the device for is a solution to their clinical condition. That is why the device is brought intermediated into the process, and it compromises it because it doesn't work.
You concede that in paragraph 4, the characteristics and performances referred to in sections 1, 2 and 3 must not be adversely affected to such a degree that the clinical conditions and safety of the patients are compromised, which would tend to suggest that whether it's badged as safety or whether it's badged as not achieving performance,
Indeed.
it compromises or is capable of compromising the health of the patients.
Indeed, sir. Well, I promise to stop on that bone. So that's a whistle-stop tour of the statutory regime, but 4 points to take from it, which may be blindingly obvious. Firstly, approved bodies are appointed to perform conformity assessment procedures by reference to essential requirements. Those essential requirements are concerned with, as we've just been discussing, the clinical condition of the patient, if I can put it in those more neutral terms, and also the performance characteristics of the device. Third, a conformity assessment procedure involves the manufacturer demonstrating to the approved body that the device meets those requirements. Fourth, an approved body keeps any approval under review. It's entitled, indeed should, review the certification, and it may, in appropriate circumstances, suspend or withdraw a certificate as appropriate. And a final point, there's nothing in the statutory regime to suggest that before a certificate is suspended, there is some burden on the BSI in this case to demonstrate that the device is dangerous. If I can put it that way, as we've been using that as a term of
Can I
art.
get back to your third point? I'm sure you showed us this, but I failed to note it. Which is the regulation which illustrates that it is for the manufacturer to demonstrate compliance with the essential requirements?
My lord, that is a good question. Allow me to... Well, I suppose as much as anything else, it's A45. An approved body is a conformity assessment body, and a conformity assessment involves demonstrating that the essential requirements are met. So let me turn back to 8.
I can short circuit this. I fully accept the words of 13.3. A relevant device falling within Class 2B may bear the UKCA marking only if its manufacturer, my client, fulfills the applicable obligation.
I see. Thank you very
No
much.
dispute.
I'm very grateful, and my apologies, I'd taken you to that, but I maybe hadn't underlined that point from it. I'm very grateful to my learned friend.
Sorry, which provision is that?
That was 13.3, so that's on
13.
page 253 of the bundle.
253.
Yes. Yes, that's the England, Scotland, Wales provision. The page before it's the Northern Irish provision. So the test throughout is, are the requirements met? Factual background, my lords and my lady, 4 headings. Firstly, the original certification of the device. Secondly, why the BSI decided to suspend the certificate. Third, the process that the BSI followed. And fourth, very briefly, the fairness of that process, because that was something canvassed in some detail before Mrs. Justice Laing. The original certification, the basic chronology, is at paragraph 10 of my skeleton argument, which is at core bundle tab 9, page 88. conscious that you've read it, so I won't walk you through it again. The basic position is that the device was first certified for relevant purposes by the DQS, the German notified body, in May 2021. An application was made to the BSI in 2022, certification in August of 2022. I've already made this point, but it's important to understand two things about that original application to the BSI. Firstly, the German certification was on a reference basis. We've discussed that. Secondly, the original UK certification was an abridged assessment process because it was already certified somewhere else. And it was a light touch review, if I can put it that way, as a consequence. The easiest way, rather than describing that to you, perhaps if you could take up Mr. Tunbridge's first witness statement, that's at supplemental tab 12, pages 280 to 81. And paragraphs 25 to 28 are... I encourage you to read those rather than reading them to you. So it's page 280, paragraphs 25 through 28.
So which give me the paragraph?
25 through to 28, so over the page from 280 into 81.
Sorry.
Yeah. So, sorry. So the point is a short one. That original certification was on a light touch basis, and you'll anticipate my submission here. RRR places very heavy reliance on the fact that we have previously certified the device in 2022, and so we have changed our mind. That assertion has to be seen against the relevant backdrop. The technical file review that the BSI has just conducted is the first such technical file review in relation to this device on a full basis. It's qualitatively different to the process it conducted in 2022. If it helps, the way my client has explained it to me is imagine lining up 6 lever arch files in front of you, and on a light touch review, you would open it and dip into it in a couple of places to satisfy yourself that there is something there, if I can put it that way.
Is that what the phrase is, sampling across the products and sampling within the technical file itself?
Yes.
Mean?
So there's...
I couldn't understand what sampling across the products was.
Sorry, I've actually put the paragraph...
So, I'm so sorry, it's paragraph...
No, I've put it away, that's my... But yes, exactly so. As I understand it, the position is that what happens on an abridged certification is that there is a dip sample, effectively. The technical bundles, which would be considerable, are dipped into at various points. What happens with a file review is you take the lever arch files, you line them up, and you start reading at page 1. And that's the difference between the two processes. Before moving on, I do quickly want to address a point that's raised twice in my learned friend Scallop's argument. And that's the suggestion that this device was recommended for recertification by the BSI 2 days after the application for interim relief.
Just before you get there, sorry, can I just go back? Is this device German CE certified?
Yeah.
What was said by Mr. Tunbridge, according to this, is that it could be marketed in the UK on the basis of that German CE certification.
Precisely so.
So can it still be marketed on the basis of that?
This is one of the points that I'm going to address you on. One of the points I addressed Mrs. Justice Laing on as regards the balance of convenience, that the device still can be certified, it can be marketed in the UK under that CE certification. Now, in fairness, I think Mr. Happenstall would say, well, that's going to be difficult for us because people will know that it's been suspended. But the position is that there will still be a valid certificate for the purposes of the UK.
Yes, but it's not unlawful, therefore it's not an offence.
No, it would not be an offence for them to market under the CE certification. Were they to have the CA certification suspended, and then to market under the CA certification, that would be an offence.
Right. But in practical terms, this device, on the face of it, can continue to remain on the shelf and be purchased by people.
Subject only to any action that the MHRA might take. That is correct. My client can do no more than suspend. It cannot act against the CE certification because it hasn't got the power to do so.
No, but in terms of the balance of convenience, from your client's point of view,
Indeed.
you say we can withdraw, we should be entitled to withdraw our certification.
Precisely so.
And in the balance of convenience, actually, unless the MRSA steps in, actually there won't be loss suffered by the manufacturer because they can continue to market it for as long as the German regulator maintains its CE marking.
Precisely so. Now, there wouldn't eliminate, in fairness to Mr. Hamilton, it wouldn't of course eliminate all of the loss because there's going to be opportunity cost. If my client suspends the certificate, he's going to, as I understand it, need to notify other certificating bodies. He's going to have a dialogue with them. But you're absolutely right. The core point about marketing remains that way. And that's why when Mrs. Justice Laing says in her judgment, well, I don't need to be too concerned about this because if there's a real problem, the MHRA can step in. We say actually that's a point that really should be looked at 180 degrees around.
Yeah, okay, well, I don't want to take you out of your way, but it was just simply...
Question of fact.
Well, you pointed us to paragraph 10.2.
Yes.
And my understanding, having looked at it, the regulations, was that continues to be the case.
That's absolutely the case. And that was absolutely something that was canvassed before Mrs. Justice Laing. There's a question that went to the balance of convenience. Just to knock on the head if I can, the suggestion...
You would presumably, if you were to market under the German mark, have to relabel all your products.
Yes, there are going to be costs, there are going to be opportunity costs. We don't say that it would be a zero cost process because they're CA marked and stamped now. There may be questions about packaging, there may be questions of another kind.
Yeah, but you said it's not a product recall and it's not unlawful to sell.
So it would be unlawful if you were able to suspend and suspend it.
Yes.
It would be unlawful to sell under the UK mark, but it
Yes.
wouldn't be unlawful to sell with the German mark.
Precisely so. And we say, and that's because my client can do no more than is within its footprint. It may be that it lies in the gift of others, taking their own view independently to assess whether or not they're going to step in as regards to CE.
But how would it... We'll get on to anybody else in a little while. Let's just assume it's down to you.
Yeah.
You withdraw the certification. What practically has to happen then? Does the manufacturer have to recall in order to cross out the certification on products which are on the shelves or with retailers? Or do retailers sort of just basically take a marker pen and cross out something? Or how does it... What practically happens? Just tell me. If you do what you say you should be entitled to do, what happens?
I will have my gown tugged if I misspeak in this respect. My understanding is that a device cannot be marketed, so there would need to be, I think, a limited recall of devices under our certificate. The device would be good, if I can put it that way, for the CE certificate, but there would need to be a repackaging of the device. If I could turn my back for a moment just to confirm that that's correct. And that there would be no new sales. So what is on the there would be no new sales. So what is on the shelf might need to be recalled, if I can put it that way, because it would be unlawful to sell under the CA certificate.
Or in practical terms, the manufacturer could just call up a retailer. I mean, I'm assuming, I don't think there are massive numbers of defibrillator shops up and down the country.
I don't think Robert Dice have branched out yet into defibrillators, though no doubt they will shortly.
But so that, in practical terms, presumably there could be a sort of less elaborate process.
If it helps, the devices are all marked with the alphabet soup of all the marks that the device carries. So that the actual printed mark on the device is UKCA, CE, and others that apply in other jurisdictions. So the UKCA mark practically would have to come off physically the device. That's the practical consequence.
So just reverting to this question about the suggestion that my client has approved the device for recertification again. My client was concerned to read that suggestion in the skeleton argument. What the claimant appears to be referring to is a quality management system audit that was conducted at around this time. And Mr. Tunbridge has dealt with this in his second witness statement. I'm not going to turn it up, I'm mindful of the time, but the position is really rather straightforward. The BSI as an approved body conducts ongoing scrutiny in a number of different areas, one of which is quality management systems. But product design, technical files, so on and so forth, are all different. And what the respondent seems to be relying on is an audit of its QMS systems, its quality management systems, but not as regards the technical files. So it covers one part of the various areas of scrutiny that the BSI is required to assess, and it goes without saying that therefore doesn't mean that the device has been approved wholesale for recertification. My client doesn't have concerns at this point in time about the QMS processes. So my client did read that paragraph with a bit of concern because it reveals with respect a misunderstanding of the nature of the statutory regime. But I won't take you to Mr. Tunbridge's second witness statement. If it assists paragraph 3 and 5 there will help you on this point. I've already addressed you on the other suggestion that recurs in the submissions, which is that BSI has changed its mind. You've already heard my submission on that. It is part of the BSI's role to ask itself the question in an ongoing basis, should we suspend or revoke? And what it's done is something Parliament has anticipated that it might do, and it's done so in the context of a different kind, a qualitatively different kind of scrutiny. That leads me to my second heading, why the BSI has decided that this device should not be on the market. For that, we need to go back to the BSI's assessment report, which sets out its reasoning in this respect. That's at Core Bundle tab 13A, starting at page 165. The best place to begin for these purposes is page 167. That's the very terse executive summary, but you get the point right there. The technical documentation provided does not meet state of the art and fails to identify evidence in full of meeting all essential requirements which apply to this device. So that is the kind of banner headline, if I can put it that way.
Of those, the second one, the essential requirements, I understand, because you took us through the regulations. Where did you show us there's a requirement to meet state of the art? Is that a regulatory requirement or just something else?
State of the art is a question that goes to equivalence, and so the state of the art comes into the analysis at the equivalent stage. So the question is, what is state of the art as regards this device? Does your device fit within it? If so, it has an assertion, a proper assertion for equivalence. So that's where state of the art fits within the logic chain, if I can put it.
Sorry, you're going to have to decipher that.
That's fine.
Use words of fewer syllables for me.
The fault is 100% mine.
Essential requirements, I understand, because we saw them in the regulations as a concept.
Yes.
State of the art, you say, is to do with equivalence. In other words, what? It works in the same way as another product, which meets the essential requirements.
Precisely so. So that's my understanding, that state of the art refers to what is the something of a tautology, but what is the state of the art as regards a portable, in this case, defibrillator? What should a portable defibrillator do? How should it work?
That sounds like essential requirements to me. State of the art to me normally means the best that's out there.
Yes, and that's how it's, well, and also it has a term of particular meaning in a patent context as well. My understanding in this context is that the state of the art is a part of the analytical chain as regards equivalence. The first question is, what is the state of the art? Here is the device in respect of which equivalence is asserted. What is the state of the art as regards that device? And what that means is, how does that device operate there are also, and we'll see this further on, there are also standards. So the Resuscitation Council has standards. And so the device is then assessed by reference to that device. That device is said to be consistent with the state of the art. That's the equivalence device. And the question is, does my device also meet the same? So to take an example, is my device blue and the other one's green? State of the art doesn't cover whether or not they're blue or green. State of the art covers the essential functioning of the device for clinical purposes.
Where's the criterion state of the art come from?
Yeah.
I'm being handed it from me. So if we go back to the authorities bundle, in paragraph 2 on page 450, which was the page that we had open earlier, I think this is paragraph 2 within Annex 1, so that would be on page 20.
I think pages, we haven't got pages.
Yes, indeed, it'll be page
I haven't got page
29.
numbers now.
I'm very grateful to those instructing. Paragraph 2 on page 29 of the version you have within Annex 1. The solutions adopted by the manufacturer for the design and construction of the devices must conform to safety principles, taking account of the generally acknowledged state of the art. So that's where this, my apologies, my lord, that I wasn't able to assist you immediately on that point. But that's where it comes into the statutory regime. So turning through the assessment report, if I can, onto page 169, you'll find here, page 169, a very basic bar chart, 3 major non-conformities, and then turning through from there to page 173, conscious of the time, so I'm taking this reasonably quickly. Audit objectives are not met, major non-conformities identified, recommended corrective action closure required, major findings. The audited organisation may, and I underline may because I'm going to come back to this point later, be recommended for continued certification based on satisfactory closure of all major findings and, if applicable, a satisfactory corrective action plan for all minor findings shown in this report. Please submit a plan through the BSI Connect portal detailing the non-conformity, the root cause correction and the proposed corrective action. So what we're saying at this point is there are major non-conformities, and if subject to a satisfactory correction action plan, you may continue to be certified. And as I say, I'm emphasising the may because it goes to a point that I need to pick up later.
So this was, that sort of gave them a week to do it.
They were given a week to provide a corrective action plan, indeed. Turning now, if I can, to those major non-conformities, starting on page 176. And I accept that the technical language here is terse, and I may not be able to assist you in respect of all of the aspects of that technical language, but I hope I can give you the thrust of the concerns. First major non-conformity, design verification provided is incomplete and does not sufficiently provide evidence of meeting the design inputs. And then, if we scroll down maybe to Doc 1995, failures for the device are noted. These include, so there is here indeed at least some concerns as regards danger, if I can put it that way. These include major safety-related failure modes such as sparking and burning, which are not satisfactorily explored and root cause determined. The failure rate, as only 3 devices were tested, is considered extremely high and not represented by the risk management file. So this is the overall, and you can see the clause requirement, essential requirement 1, must be designed and manufactured in such a way that they will not compromise the clinical condition. This is, and I accept that it's highly technical, but the conclusion of my client is that that essential requirement from the directive has not been met. Turning through to 178, the second.
So is this basically saying we tested 3 devices and there were, the device failed, it just didn't work, or?
That's certainly my understanding. It's fair to say that
I didn't understand you to have tested the devices. You're
No,
just reviewing
the
the
position
file.
is that they've tested the devices, and this is the results that have been provided to us, and we've said we have concerns about the failure rate that arises there. Right at the bottom, IFU declares a 2-year warranty effective, a 2-year shelf life as batteries are not rechargeable. No evidence is seen provided of meeting this IFU claim despite a request for review for the full technical file. So again, that's a technical point. What's being said, as I understand it, is you assert that there's a 2-year shelf life, the batteries aren't rechargeable, at the end of 2 years you'd need to buy a new one, but you haven't provided evidence to support the fact that it's going to work for 2 years. So that's the nub of the complaint, or the concern there. And we've asked for it, and you haven't given it to us. In relation to the device. Now, it's fair to say there are a considerable number, and in particular when it comes to the third major non-conformity, there are a considerable number of technical points. But as I say, I hope I can give you the thrust of them in order to sustain my core submission. Page 178, the second major non-conformity in relation to preclinical data. Full evidence of a technical file was not provided despite requests. Specifically, no evidence was supplied of surveillance of lifetime shelf life, transit testing, and SWI potential items. So just to pick up on transit testing, for example, where a device is going to be put on a flatbed truck and bounced up and down a motorway, or where a device is going to be put on a container ship and sailed across the ocean, it is necessary to provide evidence that you've demonstrated that it will work on arrival. So that's the point that has been raised there.
So this has nothing to do with the portability of this defibrillator.
No, as I understand
as such, in the hands of the user.
No, this is to do with. This is to do, unless I'm told otherwise. Transit testing means demonstrating that the device can transit and still work, and that is part of the burden that lies on somebody who wishes to market a.
Yeah, but you're saying that begins and ends with shipping into this country.
We're shipping into this country and transporting to the shelf. Yes. It's not saying, show us that when somebody puts it down, at least unless I'm told otherwise, when somebody puts it down on their shelf at home, you need to provide additional evidence as regards that. It is transit testing.
Yeah, I mean, this whole product is supposed to be a portable,
Indeed,
personal defibrillator.
Yes.
So you'd hope that it's robust enough to survive people carrying it around, which is
The essence of the device. And the
but
question...
You're saying that isn't what
Well,
this is aimed at.
What this is aimed at, as I understand it, is transit testing to the shelf, if I can put it that way.
Right.
So we're saying you haven't shown us that this device, you've got to demonstrate it. You can't assert it. And this is a theme that runs through. You can't just assert effectiveness. You have to show. And we're saying we haven't seen sufficient evidence in that regard. Now, the paragraph that I took you to earlier, on page 179, is at the beginning of a fairly long 5-page chunk as regards clinical evaluation.
So the three non-conformities are the one that you showed us at page 176, the one that's at 178,
And the one that's
and
at
the one
179.
at 179 through to
83.
Right.
Those are the major non-conformities. There are 2 other minor non-conformities.
Yeah.
So, not compliant with state-of-art methods, fails to supply sufficient data in support of the device under review, including but not limited to the following identified gaps. And here we have the conclusion. At this time, there is not considered to be evidence in support of safety and efficacy of the device. And then we have a very wide range of concerns. I'll touch on just a couple of them because I'm mindful of the time, and the critical point, as I say, at least for these purposes, is the overarching conclusion, which, you know, Mr. Hempstall will say, we absolutely don't accept this. We absolutely do not accept that this is correct at all. But from our side of the court, we're the BSI, and we've reached this conclusion. And that's the reason we're here, because we take incredibly seriously the conclusion that we've reached. Some of them relate to the search. So under searches, you'll see this discussion of the adequacy of the analysis of the underlying scientific research that's being done.
So where are you? Sorry, which paragraph?
So if we look at there, if you look at the underlined headings, general within searches, the concern here is that there is deliberate exclusion of possibly statistically significant data in a meta-analysis of SOTA, the legal manufacturers
So what is a meta-analysis of SOTA?
A meta-analysis of SOTA, as I understand it, is an analysis of all of the studies in the field and all of the standards in the field.
What does SOTA stand for?
State of the art.
State of the art, right. So meta-analysis?
Meta-analysis involves looking at all of the information that would underpin, if that makes sense, and would also demonstrate compatibility with, on the part of this device, SOTA.
My understanding of meta-analysis is you look at other people's papers
Yeah,
and collate what you can get from them rather than doing your own research.
precisely. It's an aggregation exercise. So there are concerns here about the adequacy of the scientific underpinning, if I can put it that way. Turning over the page and heading into the rather long collection of bullet points. And as I say, I will do my best to assist you with the technical detail, albeit I may not be able to assist you in full with everything. The second bullet is important. The legal manufacturer continues to maintain that energy is not a determinant factor for defibrillation, and that current is the mechanism by which defibrillation occurs. Based on this, comparative peak-to-peak current of SOTA devices is discussed instead. Based on this metric, the device is consistent with SOTA. So that's RRR's assertion. Here's the conclusion. This is not considered to be SOTA and is not considered to be in line with the assessment of BSI clinicians or guidance documents of the UK and the EU. So that's my client's conclusion. You are saying that this is effective and consistent with the state of the art because energy isn't the determinant factor, current is the key. Our answer is, we've seen what you've said, we've thought about what you've said, we've taken it to, the BSI clinical experts don't agree, and we don't consider that it's consistent with guidance. Next paragraph, general waveform, biphasic and monophasic waveforms are discussed. Energy delivery is generally stated, but SOTA energy delivery levels and types are not discussed sufficiently or linked to how the device under review must or will perform. The legal manufacturer, and it should say, I think, legal manufacturer's stance that this does not impact therapeutic delivery remains out of alignment with current SOTA of the EU and UK consensus statements such as the UK Resuscitation Council. Next paragraph again comes back to the point that my lord was making earlier this morning. While the statement is made that it is the current, not the energy, that provides a therapeutic effect of defibrillation is biologically true, the energy delivery is a mutual measure of current and voltage to overcome skin resistance based on the waveform delivery. Now, I don't promise to pass that in full for you, but I think what's being accepted here is the basic assertion that current is what provides the therapeutic effect is accepted, is common ground. But what's not accepted is what follows in the next paragraph. Evidence that the low energy delivery provided by the device under review is sufficient for defibrillation is not seen supported by SOTA or clinical evidence. No statistical assessment of SOTA for the energy delivery is seen, and current consensus statements are not seen as sufficiently considered. References provided in support of the legal manufacturer assertions are considered to be insufficient and not SOTA.
I mean, I don't quite understand that. If it's accepted that it's current, not energy, that provides the therapeutic effect of defibrillation, if that's accepted as true, why does it go on to say that evidence that the low energy delivery is not supported, etc.? I mean, the second sentence doesn't seem to acknowledge that it's actually current. It seems to accept that current is the provides the therapeutic effect, but it keeps banging on about energy delivery. Well, I don't find it easy to reconcile the second sentence with the first.
My understanding is that it is the claimant's case that current is clinically the therapeutically necessary function, not energy.
Well, and
that's accepted. And we can deliver the same current via considerably less energy than any other device on the market. And that is what is not accepted by my client.
Energy is just the product of current and voltage. It says mutual measure, unless I've forgotten the equation. It's the product of voltage and current.
Yeah, indeed. And what is said by RRR is that its device is able to deliver the same current, albeit via a different voltage, as I understand it, and that is what is not accepted by my client. It may help, the next paragraph may assist. Other similar statements are made, such as while energy joules remains ingrained in defibrillator vocabulary to describe shock strength and current, amperes has been shown to be a better indicator for defibrillation success. How the device under review will achieve demonstration of equivalent or superior performance at lower joules is not stated or derived. So what's being said here is, in principle, if you could show that, we would not have an objection. But the device under review, you haven't shown us that you will achieve an equivalent or superior performance at lower joules. So that's the difference between us. It comes back to the point I was making in opening, which is that equivalence is what's in issue here, and what's being said is
Well, they're saying
we are different but equivalent.
But they're saying we can deliver the same
Yes.
current using a lower voltage.
Yes, and we're saying you need to demonstrate that that's the case. You can't simply assert that that's the case.
Although the focus on energy is just slightly irrelevant. It's just, can you deliver? It seems to be, can you deliver the required current using a lower voltage?
I think that's right, my
Unless
Lord.
they've reinvented the laws of physics, that's necessarily that's necessarily what's being asserted.
I think that's correct, my Lord. So going on into this paragraph, the statement made the device is able to deliver equivalent current to the heart when compared with SOTA devices is not accepted as a performance metric. The method by which the device will demonstrate equivalent resuscitation ability is not documented. The assertion that the device is able to deliver equivalent current to the heart when compared with SOTA devices is not in alignment with SOTA, as defined by groups such as the UK Resuscitation Council.
Well, why do they not accept as a performance metric the delivery of equivalent current if they accept that it is the current that provides the therapeutic effect? I don't understand. If they've accepted that it's current
Yes.
that provides the therapeutic effect, why do they say that the device is able to deliver equivalent current to the heart is not accepted as a performance metric? I mean, you may say it doesn't do it.
Yes.
But why isn't it the relevant performance metric?
Well, my Lord, maybe I need to take instructions on that particular sentence, but the overall thrust of what is being said here, I think, is tolerably clear. Looking at the sentence above, how the device under review will achieve demonstration of equivalent or superior performance at joules is not stated or derived. Looking at the next sentence, the method by which the device will demonstrate equivalent resuscitation ability is not documented. So what's being said here is, you have failed, coming back to what was being said earlier, the burden lies on you to demonstrate that your device is suitable for being placed on the market, and you have failed to demonstrate that that is the case as regards this device. So that's the pushback my client's giving.
I understand that point.
Yes.
You're saying you, manufacturer, have not demonstrated that you can deliver equivalent current. Sorry, to the heart.
Yes.
Using delivery of current as the relevant performance metric, which seems to be what's accepted. What I don't get is why that is not accepted as the performance metric. It's that sentence, the statement made, the device is not able to deliver equivalent current is not accepted as a performance metric. That I don't get. I can fully understand you saying you haven't proved that your device does it, but why isn't it the relevant performance metric?
My Lord, I can take instructions on that particular sentence if it assists. I may even be able to address you on it in my reply.
Okay, well, don't worry. I mean, you were right when you said that this is not altogether easy to read and follow.
No, and my Lord, there is a parsing of it that you may find assistance from in Mr. Tunbridge's first statement. I won't take you through it all, but if I could take you to tab 12 on page 287 of the supplemental bundle. So paragraph D, I won't read it to you. I might suggest that it may be easier for you to read it yourselves.
I'm so sorry, which page was it?
Page 287
287.
in tab A.
Oh, okay, well, just taking 287D1, I can't, he says that the claim that the comparison must be based on current rather than energy was not accepted. Well, why? You showed us a paragraph that says, whilst the statement is made that it's the current, not the energy, that provides the therapeutic effect of defibrillation, is biologically true, which seems to accept.
I think it's only my understanding, my lord, and if needs be, I can take some instructions on this and, in the shorter German, is that the next sentence is the key. The claim that the comparison must be based on current rather than energy for effective defibrillation was not accepted, as is not supported by the currently commonly accepted scientific opinions for resuscitation councils in the UK. Such low energy delivery would be considered novel in the space and would require clinical evidence in support of its use on human patients in a controlled environment, which has not been conducted / provided. And so I think that the nub of it, as I understand it, is that whilst it might in the abstract be right that current is key, I don't. My understanding is it's not been demonstrated in this case to the standard that would be required by my client, and further in particular, it's not been demonstrated that it can and will be delivered at that level of energy. Now, my lord, I don't want to pass too much further what is said here, but I will take instructions if it will assist you, because I think the point that's troubling you.
I understand the second point.
Yes.
Which is this product can't deliver
Yes.
the necessary current.
Yes.
Because it operates differently. What I don't get at the moment is whether it is accepted that it's current, which is the key for defibrillation, which does seem to be accepted.
My lord, it might. I
At least
understand
in
entirely.
at one place it seems to be accepted, and then another place it doesn't, and I can't get that.
I understand that entirely. It may be the most effective use of my time to take instructions and revert, but I will, because I understand entirely the question as it's been put to me. But what that where we end up in a document which is on any view a technical document, rightly a technical document, we say, in respect to the complicated scientific question, is the overarching conclusion, which is not in doubt. It's repeated in Mr. Tunbridge's witness statement, that the BSI is not satisfied that this device is effective. You haven't made out your case. Now, Mr. Tunbridge's case will be, well, we haven't had a fair opportunity to do so, and we don't think it's fair, and we don't think it's right. But that's for the judicial
I don't think
review.
you mean Mr. Tunbridge.
Tunbridge?
Mr. Heppenstall.
Mr. Heppenstall.
Yes.
It's good news if it is Mr. Tunbridge.
I can reassure the court and disappoint Mr. Heppenstall that that's not Mr. Tunbridge's position.
Mr. Johnson, I think we have to point that you've taken the view that the evidence is insufficient. I think you need to move on to your legal arguments, because I don't really think you should go into after the shorter German.
No, my lord, what I certainly won't do.
Yes.
I'm very grateful for that indication. There are some important points, moving on then to the authorities, there's some important points of agreement between the parties that I can take direct from my skeleton argument. If I can ask you to turn that up, it's in the core bundle at tab 9, page 94. What's agreed, I understand, this was agreed from the authorities bundle, is what is in paragraphs 22 and 23. But I do want to pause just for a moment on those paragraphs, because we say that they're important. 22.1, the court will be slow to grant interim relief against the public authority to prevent it from exercising its powers in good faith. This is a weighty factor. Now that, as I understand it, is agreed, and the proposition that we take from the ABI case is agreed, and as set out there by Lady Justice Rose, maybe it was Lord Justice Rose in 1999, no, Lady Justice Rose is 2017, that is to say the public interest in permitting a public authority to apply its policy and be free to act as it proposes to in the public interest in a particular sphere of activity as it judges that interest. So that's agreed. Paragraph 22.2 is agreed. Where the claim does not disclose a strong prima facie case, this will weigh against the grant of relief at the balance of convenience stage. So that's the Ofsted case. I was proposing to turn that up, but I think you'll be familiar with it, and so I won't. Paragraph 23 is also agreed. When balancing or weighing factors relied on by a public authority, some factors are more weighty than others, if I can put it that way. When putting factors into account, some weigh more heavily, and then familiar authorities decide cheese, British American tobacco. The point is, the maintenance of public health is a very weighty factor in the balance of convenience. So that is all agreed between the parties. And if I can put what we take from these authorities in a nutshell, if public health and safety are an issue in this case, then the order below will need to be set aside. The court is slow to grant interim relief, a strong case must be shown, and public health is a particularly weighty factor. As it's put in British American Tobacco, protection of public health is recognised in law as one of the highest of all public interests that can be prayed in aid. And so we do say that the logic that the court deployed, which was to say to itself, public health is a paramount factor, but it doesn't matter in this case because you haven't shown the device is unsafe. We say that's an error of law. If public health comes in, and we say it does, and I hope I've made that out on the facts, but I'll make submissions on it too, then the order below should be set aside. Now I said I would turn it up. I don't think I need to. If I ask you to turn over to page 96 to the citation from Hadmore there, I said this right in opening and I'll say it again now. Facts of Hadmore are rather remote from this case. It's about a trade union dispute. But the key point is that you should not set aside the reasoning of Mrs. Justice Laing just because you would have reached a different conclusion on the balance of convenience. The question for the court is a two-step question. Firstly, as put in Hadmore, is that judgment below based on a misunderstanding of the law or of the evidence? If it is, then your discretion arises, if I can put it that way.
I think we're very familiar with the principle that we don't just
label
substitute
it.
our own views
No.
on a question of discretion. The question is whether the judge erred.
And that's the task before me, and that's the task that I hope to satisfy you I can meet by turning to the judgment itself, and that's at the core bundle at tab 6.
Yes.
Very briefly, starting at paragraph 12, 76, the claimant made an urgent application for interim relief to prevent BSI from suspending the certificate, so that's the backdrop. The test is set out at paragraphs 14 to 17. The very end of paragraph 17, I would demur from slightly, but make some allowances for the fact that it's an extempore judgment. The strength or weakness of the claim is likely to be a significant factor in assessing the balance of convenience. The test, as we've just seen, is whether or not there is a strong prima facie case is a factor, but as I say, allowances, I don't mean it glibly, allowances do need to be made for extempore judgments. We do say that slightly lowballs the test. Moving on.
Where'd you get the strong prima facie case from?
So that's the skeleton argument. It is from the Ofsted case. Jeffrey Boss. It's not a threshold question.
Yes, 22.2.
22.2, and that's agreed.
Thank you. Yeah.
The core of the reasoning, the guts of the reasoning, starts at paragraph 21. So just to take this in stages if I can. I accept that the claimant will suffer considerable commercial and reputational harm, both in the UK and in other countries, if the certificate is suspended, even if only up to the date of trial. So the position is, trial's going to be in June or July. They won't be able to sell here. There will be an opportunity cost in terms of communication with other regulators, and it's their only product. And I think that's what the judge goes on to say almost immediately afterwards. I accept that other jurisdictions would rapidly become aware of the suspension and would likely commence their own investigations. That's the opportunity cost point. You're going to have dialogues with the other regulators. The device is the claimant's only product, and so its entire business could be threatened. And I do underline the word could. There isn't a finding here that this would threaten the entire business, but there's a finding that its entire business could be threatened. It's fair to say that the device can, of course, still be sold in multiple other jurisdictions. If, as the claimant submits, this is a life-saving innovative product, it is not in the public interest to put it out of business. Now, I do comment on that last sentence. It is important not to lose sight of the fact that this is a device that is seeking certification on an equivalence basis. There are other similar devices on the market. So we're not looking at a market where one portable defibrillator is there or there is nothing. And so, of course, it's right as a broad proposition that it's not in the public interest to put any company ever out of business, completely accept that. The reasoning we say is slightly peculiar if, as the claimant submits, this is a life-saving innovative product. Well, this is a product on a market where there are other products of an equivalent.
This is your point, that what the effect would be to, as it were, take this product off the shelf.
Yes.
But there are other products on the shelf,
Yes.
which you are satisfied are effective.
We or other approved bodies, it may well not be us, but that's right. Yes.
Yeah, okay. Somebody suitable has been satisfied
Yes.
are effective. You say you're not satisfied, this one is effective.
Yes.
Therefore, for the period,
Yes.
the public should be prevented from buying this product
Absolutely not.
Well,
rather than others.
what is the evidence that there are other portable defibrillators? Because one's very familiar with the ones that are wall-mounted, but as I understand it, the judge uses the word innovative, and I thought the evidence was this was a bit of a breakthrough to have something you can put in your glove box or into your bicycle pannier or whatever.
My understanding is that the innovation lies in the delivery, the different delivery, if I can put it that way.
Not just in the portability.
No, I don't. And that's consistent with the
But
fact
it
that
is.
this.
I thought it was marketed as a sort of a personal defibrillator, in the sense, as the Lord said, it's not the big one that's mounted on walls in public places or hopefully this building. It's a smaller thing which actually can be transported more readily. I thought that is the way it's marketed. I thought amongst other things.
What I actually asked is what was the evidence? Paragraph 15 of the claimant's evidence is that RRR created its device, which is the world's first personal AED designed to be lightweight, easy to use, etc. But so is there evidence that there are other equivalent, not in the sense of clinically equivalent,
No,
in the sense of portability, lightness, and so on?
Well,
I don't want you to.
I don't know that my lord. I don't think my client has, in his evidence, said there are lots of other devices of this kind, and I can't give evidence to the court.
No.
And this is obviously an equivalence application, so there is a device that is said to work in the same way. I know that doesn't go all the way to your point, which is, well, it might work in the same way, Mr.
Well, I'm picking up
I
on the judge's word innovative. If this is the only one of its type, that's slightly different from what you were saying was. If we take this one off the market, there are lots of others which are just the same.
Well,
I don't know what.
Very clear instructions. I don't, in fairness, have evidence to point you to, and so I have to. Maybe I have to qualify what I've said, but those are certainly my very clear instructions in that.
But there are other portable AEDs available.
That is absolutely what I've been instructed, my lord. Turning to paragraph 22, this is really the key paragraph, and I think I need to take it sentence by sentence. This is why the judge decided she was going to grant interim relief. If BSI is restrained from suspending the certificate pending trial, it will be deprived of its power to prevent the claimant from operating in the UK. Yes. Or at least marketing under a CA certificate, to be more precise. Yes. And we know, agreed, that that is a particularly weighty factor when seeking interim relief against a public authority. Albeit that gloss isn't here, that is an agreed principle on the authorities. B, public health and safety is obviously a paramount concern. Again, agreed, consistent with the authorities we've seen before, public health and safety, when you're weighing in the balance of convenience, is paramount, and that follows from the authorities we've seen. The key word in this judgment is the one that follows, however. That's the hinge word. That's the nub of the logic. However, there is no evidence that the device is a current risk on health and safety grounds. So what's being said here is public health and safety is a paramount concern. However, in this case, there's no evidence that the device is dangerous, to use the way we were articulating it before. And we say that's the error. We say that's the error of law.
This is, I mean, we're really drilling now down to the central
Yes.
problem. My lord, to put to you, if this is the only portable, handheld, personal defibrillator on the market, and there's no other alternative, then it's not, as you were putting it to me earlier, that it's simply taking this one off because it might not work, and there are others who you are satisfied will work to standard.
Yes.
Okay, I'm not saying they necessarily will succeed, they'll work to standard. If this is the only one that's portable, such that if you take this off the market, you're basically, as a member of the public, at risk of somebody finding a wall-mounted, publicly available defibrillator within range, within the few minutes you've got. It's a very different proposition, isn't it?
Well, my lord, I see that point. My very clear instructions are that this is not the only portable defibrillator on the market. I can't put it any higher than that. I shouldn't put it any higher than that. But that is what I understand to be the case. And I suppose I might put it this way as well. Even if it were right that this were the only device of that kind on the market, if it doesn't work, people are going to organise their lives in that way, if I can put it that way. They're still going to be choosing. Now, I understand the point is considerably less forceful.
You won't organise your life around it. You will just have it in the hope that either it will be used on you or you will be able to use it on somebody else. In circumstances where it's complete happenstance whether the event occurs within range of another wall-mounted or publicly available defibrillator. I mean, it's a question of whether the public is harmed in that circumstance or not.
Well, I would qualify that only in this way, my lord. Imagine your Brickport chambers and you're very seriously need a collection of defibrillators. You might buy a portable device that sits at reception. You might buy a wall-mounted device that sits in the classroom. These things are not, putting my competitional hat on, they would almost certainly be in the same market and be competing with each other. Let me put it that way.
Well,
so I don't think
they're at different price points, in fact, I think.
So I accept entirely, my lord, that there is a distinction, but I don't think the distinction is quite as hard-edged as it's being put to me. I think there is a little more nuance to it, but I accept the overarching position. If it's right as a question of fact that there's nothing else, there's no other defibrillator that can be picked up and carried with you. And as I say, I can't go any higher than I have as regards my instructions on that point.
I mean, I'm trying to unpick that critical sentence that you've been pointing us to try and understand what might lie behind it in the judge's mind or what in the evidence.
So what lies behind it in the judge's mind, we say, is tolerably clear. And maybe that's clear from the next sentence. Although Mr. Tunbridge refers in paragraph 8 of his witness statement to the fundamental and overarching concerns for public safety when using the device, the BSI has not identified direct evidence that the device is unsafe. So what the judge is saying is you haven't shown this is dangerous. And therefore, public health and safety, the paramount concern, isn't engaged here. And we say that's not how public health and safety works in this context. The premise is false because, as we've seen from the statutory regime, the nature of public health and safety in this context is that the burden lies on the party that wishes to market to satisfactorily demonstrate that the device is safe. The question is not, have we got evidence that the device is... Or works.
And you see, this is... I'm sorry, I'm not... I hope I'm not being just pedantic.
No, my lord, not at all.
But it goes to the heart of the questions I was asking earlier, or trying to drill down to.
Yes.
Which is, if one is evaluating the public interest in health and safety,
yes,
you need to be very specific about what you say hasn't been demonstrated in relation to this product.
yes,
and the potential effect of taking it off the shelf.
Understood. I think, my Lord, I think you have my submission, which is that the bright line distinction between efficacy and safety doesn't exist in this context, because a device that doesn't work compromises clinically the patient. And so the question that my client is asking itself is not, do we have evidence that this device is dangerous? And the question that the court should be asking itself, consistent with the way the statute approaches the placing of medical devices on the market, essential requirements, conformity assessment, all under a framework in which, Regulation 13.3, the burden lies on the respondent to show. And that's what we say is the mistake here, because Mrs. Justice Laing has directed herself that in the absence of evidence, direct evidence that the device is unsafe, in the absence of evidence that the device is a current risk on health and safety grounds, she's saying you haven't shown it's dangerous, therefore public health and safety is not an issue in the balance of convenience. It's the paramount concern. It would outweigh other things, but I say it doesn't matter here. However, and that's what we say the mistake of law is. My Lord, I think you have a question.
I was going to say, you sound as if you're criticising her for saying the BSI has not identified direct evidence that the device is unsafe. Is that's one of your criticisms?
My criticism lies in the logic of the paragraph. Public health and safety is obviously paramount, agreed. However, and what she's doing at that point in the reasoning is she's saying that otherwise paramount concern comes out because
there's no evidence
that it's unsafe. And we say that isn't how efficacy or efficacy/safety works in this sector. It's a
so you say that the sentence beginning, however, is just wrong. Your evidence is that in the absence of demonstrated efficacy, there is a risk.
Yes, 100%, my Lord. That's precisely the nub of the point. And so we say the logic chain which says to itself, public safety and health very important, paramount in fact. But don't worry about that, because there's no evidence that the device is actively dangerous, as we've put it. That is not consistent with the statutory regime. The statutory regime doesn't ask that question, doesn't impose that burden, and doesn't seek that answer. And so what's happened is that has been taken off the table pursuant, we say, to a misdirection of law. Because the misdirection of law is to misunderstand what public health and safety means in this context under the regulations. Parliament, drawing on, as we've seen, historic European legislation, has given these words a meaning in this context. My client is proceeding on the premise that those words have that meaning. Mrs. Justice Laing has said those words don't mean that in this context. What they mean is, can you show it's dangerous? And if you can't, then public health, which otherwise would outweigh, comes off the table. And we say that's the error of analysis. Sorry, my Lord.
No, that's fine. I mean, I understand the point you're making. I was going to put to you that a judge hearing an application for an interim injunction normally asks themselves where the risk of greater injustice lies.
Certainly. Yeah.
Or harm or injustice. And is that the same question, in the sense that is she not entitled to ask herself the question on a more granular level, what's the risk if I either require this to be taken off the shelf or allow it to continue to be sold pending the trial? And why can't she approach it? Why is it wrong to approach it in a more in the question that she has to answer, the judge has to answer in that more generalist way, but then focusing on the individual facts?
I understand the question, my Lord. The reason the error is here is because she has misunderstood the meaning of public safety and health. and therefore has misunderstood the factors that go into the balance of convenience in the first place. So when asking what's the benefit, disbenefit, or risk, or however it might want to be unfair, however it might want to be described, what one must do is understand the factors that go either side of the scales, if I can put it that way. And we say that she's not done that. She's directed herself appropriately. Public health and safety is obviously a paramount concern, and that's because it's agreed that it's particularly weighty. Not all factors in the balance of convenience weigh the same. That's understood and agreed between the parties.
But if we can test it just in a way that picks up on the point we've been going round and round. Well, sorry, I have, and I apologise for doing any of that. But if this was a product which was unique and might work to save somebody's life,
understood.
And there was no alternative, and it was not dangerous in the sense my lord sort of was using the expression earlier, and therefore it might not meet your certification because it may not have been proven to work, but there's nothing else that might save you, and it's not dangerous.
Yep.
The fact it doesn't meet your certification standard or concept of public health and safety wouldn't necessarily answer the question about whether it was right to take it off the shelf pending the judicial review, because you could be depriving somebody of the chance of life.
But might the answer be that this is an application for judicial review and the framework is the relevant legal context created by the regs?
Precisely so, my lady. The way I was going to put it, which is a similar point, is it's not our standard. It's not our choice. We haven't chosen the terrain within which this operates. We haven't ourselves defined what is public health or safety or efficacy in this context. That is the context in which that's the river in which we swim, my lord. And the mistake we say here is to misunderstand that fundamental point and to have regard, critically, when taking public health out of the account, to have regard to a flawed understanding of what it means to talk about the paramount concern of public health and safety in this context. That's the mistake. And so coming to your point, you'll understand I don't accept, if I can put it that way, the premise that this is the only thing that might be there, and you've already heard what I say about how people might organise their lives differently in any event. But the critical point is that the judge has to get the law right.
Can I put this to you? Suppose instead of saying there's no evidence that devices are current risk, suppose she'd said public safety is a paramount concern. There's no evidence that the device is actively dangerous. I accept that. Part of the concern of the BSI is that it has to be shown that it meets the essential requirements, including that it actually works.
Yeah.
But we're not talking about here something which is actively dangerous. We're talking about something where there's a doubt whether it's been shown to work or not. And then come down on balance and said, on balance, I think it's better that it should be allowed to remain on the market in the meantime for the next few months. Would she be wrong then? Would you say that's simply not what she did?
I say two things. Firstly, that is simply not what she did. Secondly, there isn't a doubt. So this is a binary scenario from my client's perspective. There are essential requirements. That's what Parliament has said. It hasn't said devices may be on the market and we may exercise our discretion as to whether we think something can be marketed a lot. There's lots of statutory powers that operate in that way. It doesn't work that way in this sector. And
that's assuming you're going to win the JR.
No, my lord, I think it's assuming the precautionary approach that's at the heart of the legislation. The legislative regime is precautionary. The legislative regime says devices may not be marketed. Indeed, it's going to be a criminal offence if you do. Take it very seriously. Devices may not be marketed unless the essential requirements are met. They're not optional or fungible in that sense. And so that's why we say this is not a case of it's our views as regards certification or our doubts as regards certification. And if you read Mr. Tunbridge's witness statement, he's very clear as well. This isn't a case of well, it's all very finely balanced and we're not sure, we have some doubts. In any event, so this is rather clear cut. But leaving that on one side, that's not how the regime works. That's not what Parliament has decided should be the framework of law, and it's not what we've been appointed to do within the footprint of our power.
So what you say is it's not so much that this is something special for judicial review cases. You say it's because the legislative regime defines the health and safety, what health and safety means for the public.
Yeah. Well, I say two things. I say judicial review is special because the court's going to be very slow, weighty factor to stop a public authority stepping in. We've read, you'll be familiar with all the cases, but all the Ofsted cases, which in some ways bears some similarity to this. People come and they say, I don't want that Ofsted report published because it's going to cause me harm for my school. And the courts almost always, barring in exceptional cases, say no.
Yes.
So judicial review in general takes a very cautious approach to the restraints of powers. But here, a fortiori, because this is not a situation like Ofsted where I'm making a judgment call, I'm saying, in my view, there's a sentence I don't like about how teaching works or provision for SEND or whatever it might be. It's much more hard-edged than that. And again, a fortiori, we say public policy because it's a defibrillator. Now that's the sort of bolt-on point that I don't need. I do say it's an eye-catching point. Let me put it that way. Because the framework of law Parliament has established provides that devices must not be marketed unless we're satisfied that they're safe. I've got to rattle through the rest of the judgment very quickly. I will stop by 1 o'clock.
You've got 2 more grounds to cover.
I will be very quick. I need to finish this very briefly. And it was content to allow the product to continue to be marketed during the implementation of its cap requirements. That's a slightly unfortunate sentence. You've seen what I've said in my skeleton argument about it, and that's why I underlined the word may in the report. It was not our position that the device would necessarily be marketed during the cap period. The question was, if caps were provided that were satisfactory, then we may allow you to continue to market. So we say that that is a short hearing, a short judgment, but we do say that that doesn't reflect what the documents say. And then the last 2 sentences, and you've already heard what I say on them, the device has previously been certified and approved by BSI. You've heard what I say about that. The idea of changing our mind, we say it's different qualitatively, and it's been approved in other jurisdictions as well. Well, as to that, we say that is not a factor that determines whether or not our powers should be constrained. And indeed, if anything, it balances the community the other way, because they can continue to market elsewhere.
But isn't all she's saying here is nobody's suggesting this is dangerous. If it were, you'd recall it, you'd do other things, or the MHRA would step in, or whatever.
Yes.
But that's not the territory we're in. What the territory we're in is you say you haven't had it shown to you that it works.
Yes.
And no, I think we have your submission.
Yes.
That's enough to engage the public health and safety paramount consideration.
Absolutely.
But I think she's saying this is not shown to be a dangerous product.
Yes.
We're in a different territory.
Well, she's saying it's not shown to be a dangerous product, but the error is that's the reason why she discounts public health and safety.
I have that point. I think we do have that point.
I won't repeat it. I was going to address you on paragraph 23 and about the role of the MHRA. I'm not going to. You've seen that there has been, how can I put it, some contestation as regards the role of the MHRA. We do say that relying on the MHRA to step in, I'll restrain this authorised body who's meant to do this, but the MHRA has some kind of overarching powers, and if there's a problem here, they might step in. It's a very disorderly way of thinking about how public law works, and it's disorderly, and we've seen that actually in this case, and it's unfortunate that that's the case, but I won't go any further. My lord, my lady, you have what I say on ground 1. The only thing I want to do further on it is to ask you in your own time to read 2 passages from Mr. Tunbridge's evidence. And that's at Supplemental 12, page 290, paragraph 54. That sets out the relationship between the burdens on the BSI and RRR. And then the second quote is at 292, 59, and 61 to 62. And those really go to the point, if you are with me, that there is an error here and your jurisdiction arises to consider afresh, those are the key paragraphs. And to put it bluntly, what Mr. Tunbridge is saying is we're going to consider whether we remain as an approved body if this is the way this operates. That's his evidence. This is a really serious point. Raises the question about whether we want to continue to hold designation as an approved body. BSI does loads of things, has lots of different functions. It's a large organisation. It is, the number of people behind me make the proposition, it is concerning.
I think we understand it's an important case for your client.
I won't address you on the merits of the claim at all. I can do if I need to.
You've accepted there's a serious issue to be tried.
I've accepted the serious issue to be tried. I do say that this is a claim where, we say this is a claim that is weak, albeit I recognise that there is limited force to how far I can push that point in circumstances where I haven't filed my detailed grounds. I'm having a rolled up.
Well, do you say that this is a case where, in accordance with Ofsted, there really should have been a strong case before the court granted an injunction, and that's not something that the judge has found?
Well, I make two submissions, one under ground 1 and one under ground 2 as regards that. Under ground 1, that goes into the balance of convenience.
Yes, but
And
does she find it's a strong case?
She doesn't. She says that the grounds have differing degrees of merit.
Well, she says some of the claimant's points are stronger than others.
Indeed.
That doesn't mean it's a strong case.
Doesn't mean it's a strong prima facie case, and we do say that should have gone into the balance of convenience, and that is agreed between the parties as the test, and that is not what she did in her analysis. And again, I make allowances, my lord, for the fact this is an extemporary judgment at speed, but we say that that's why I drew your attention to it before. Strong prima facie case must go into the balance of convenience, and we do say, with respect, however compressed the judgment is, paragraph 21 is an extraordinarily compressed, paragraph 22 is an extraordinarily compressed rendering of the authorities and the factors that have to be weighed.
22 and 23 is all about the balance of convenience, where the risks are. It's not about the strength of the underlying JR claim. That is dealt with, if at all,
above
in 20.
Yes, indeed.
And 19
and we say
20.
It has to come in at 22 because strong prima facie case is a factor, not as a threshold.
No, but as part of the mix.
Part of the mix, exactly. So it's not there.
And then you have a separate point on mandatory orders,
On
which I think
mandatory
we
orders.
probably ought to move on to.
Yes, my lord. I can deal with this really very quickly. There is some legal dispute between the parties about whether or not a strong prima facie case is also a threshold condition when a mandatory order is being made. And if I can summarise my learned friend's submissions, he says there's the Falco and Crawley. That is what the Falco and Crawley says, but it's
we've
been
moved
doubted.
on since then.
It's been doubted. We've moved on since then. My submission is a simple one. It's a two-step submission. Firstly, we do say the Falco and Crawley remains good law and it has never been overruled. Secondly, even if it's right that DeFalco and Crawley says, as my learned friend says it does, well, really you've got to look at the overall context of this particular factual pattern, in that context, housing, in order to decide whether, not all public law cases, but some public law cases, we say that this is that kind of case. So that's the other way that I put my submission.
You are, by virtue of the mandatory injunction, being required to do something that in all conscience you don't want to do.
Absolutely right, my lord. And the concern on my client's part is considerable because they, in good conscience, in the exercise of their expertise, exercising the functions Parliament has said approved bodies should exercise, are now being told not just don't do something, but you must do something. And we say that at the very least there should have been substantive additional consideration of the difference there as regards the balance of convenience. And furthermore, we do say that the law is different, and you've seen what I've said, and I won't repeat it as regards DeFalco, but we do say that there is something qualitatively different about being told in May. It doesn't matter what you think about this device. It doesn't matter if you think it's unsafe. It doesn't matter if you don't think it works. You have to put your name to it. You are compelled to put your name to it. And what happens if my client identifies other adjacent but in some ways connected additional points or even completely different points? Well, we have liberty to apply, but what a mess. I mean, we're going to apply and say, well, we've got these additional points that we're concerned about, which weren't quite in that report, but they're sort of in the same sphere. I mean, it's going to be very, very complicated. And the truth of it is, that barring something really extraordinary, my client is going to be told to do the extraordinary, and that is to certify something that it in good conscience thinks shouldn't be on the market. And the prejudice to my learned friend's client is considerably less, because rather than a suspension, there's a decision not to renew. That is different in terms of their concerns about reputation and so on and so forth. Furthermore, the time window, we're going to have a quick judicial review in June or July. If this is not recertified in May, not quite half of the window when they're off the market is gone. It's a really quite short window of time when they're not on the market. So we say...
If you fail to... If you refuse to recertify on the 20-something of May, and they have in their warehouse product sitting there, they can't fulfil orders that have already been made. Is that right?
That is a good question. My understanding is...
If it becomes a criminal offence,
yes, it becomes...
to market, it's presumably a criminal offence to
sell.
To sell.
Yeah, I mean,
So I think sales that are made. I mean, there will be an interim. There'll be a penumbra of cases where sales have been made but delivery hasn't been made. That may be a relatively small number of cases. If that were true, then the thing.
No, but it might give rise to a bit of. I mean, you were saying chaos, but I mean, from their point of view,
yes,
it's not very satisfactory to be told you can sell up to this date and then it suddenly becomes unlawful. It's left a little bit unclear as to what the practical consequences of that are.
Is it just the manufacturer that commits an offence, or is it a retailer?
So there is a distinction between somebody who places a device on a market and a manufacturer, which often arises because the manufacturer is somewhere else and they sell it. So both is the answer.
See, the truth is, in fact, if you withdraw certification, there has, in effect, to be a recall of all the products that are out there from retailers because they bear the wrong badge. They bear a badge which they're not entitled to bear. I thought that was what we
yes. So, and I think the process doesn't need to be a disorderly one that happens in one day. If the position is that this device is not going to be recertified in 10 days' time, then RRR is going to know, and there's going to be a process. My lord, it's never been our submission that there will be no consequences that follow for RRR. It's always been our submission.
So they would probably just say to there'd have to be a communication to retailers: do not sell this product, or do not advertise it for sale pending.
We've got a 3 to 5 day delivery period. Please don't sell it up to 10 days before, whatever it might be, to create a precaution window. But it's never been our case that there won't be any commercial cost or inconvenience. Our submission is there's a clear-cut error of law, and our core submission to you is that once that error is taken out of the picture, public health and safety comes back into the picture, then we say both the prohibitory and the mandatory order fall to be set aside. Because your discretion arises again, you have to decide the point again afresh for yourselves, and we say this is a case where it is clear, we say compelling.
Yeah, but ground 2 has to be on the basis you've lost on ground 1, because if you win on ground 1, so ground 2 has to be even if I lose on 1, then 2. Yes, precisely so.
Can I just ask a further question about the mandatory order? This is quite an unusual thing to do, because normally either the court makes a mandatory interim order about a decision that has already been made,
yes.
like the Falco case, a decision not to provide accommodation for a homeless family, or the court makes a mandatory order as part of the final relief after something has been held to be unlawful.
Yes.
What we have here is no antecedent decision that anything is unlawful because the JR hasn't been decided.
No.
And effectively a quiet time-met injunction about a future exercise of a power. I mean, is anyone aware of any case where that's been done?
My lady, we're not, and we were surprised when we saw the precise formulation of it. Now, in fairness, I think the judge was trying to give us some wiggle room by saying in such manner as it may deem appropriate, but the bottom line is there is a non-time limited freestanding obligation to do contrary to conscience what we think to be wrong, and we do say that that is a very, very unusual order, particularly in the public health space.
Yeah.
I won't address you at all as regards costs. You've seen what's in my written submissions. I won't address you orally on it at all. My Lords, my Lady, I'm very, very grateful. You've been extraordinarily indulgent with the time.
We've asked you lots of
And
questions.
quite interventionist.
Well, that's within your gift. It's supposed to be within my gift to take the interventions and finish slightly before 1:05. But I'm very grateful. And unless I can assist any further, that concludes my submissions.
Thank you very much. 2 o'clock.